Hello, this is Matt on the Moon Lambo channel. You may recall that the SEC hilariously is demanding that Ripple end up paying ultimate penalties, including disgorgement, of upwards of $2 billion. That's right, $2 billion with a B. That was the news in recent weeks. Well, now Ripple has filed its opposition to the SEC's motion for remedies and entry of final judgment. And I'll tell you two things that I found super interesting right out the gate, and then I'm going to share with you perspective from 4 different attorneys within the XRP community. First of all, Ripple is suggesting that they pay as a penalty no more than $10 million. That's what Ripple's attorneys have set forth here in this document that they filed, which, of course, Judge Torres will be reviewing. That's a far cry from $2 billion. $2 billion, $10 million max. So we'll see what happens there. One of the attorneys that I'm going to share with you perspective from made a prediction as to what is actually most likely to be paid by Ripple, so we'll get into that a little bit later in the video. Also, and this is truly fascinating. So I've talked a lot about what Ripple could potentially do moving forward if XRP were not allowed to be used in the United States for cross-border payments, for the XRP as a bridge currency via ODL. And I said, really, all they'd have to do is just use a different coin just for corridors that touch the United States, and it's not in the end that big of a deal. Well, we now found out, thanks to this document, they're doing that right now. They're not using XRP in on-demand liquidity, specifically because of all the SEC nonsense. They prefer to use XRP, but in corridors touching the United States, nope, they're not. That's just something that I had speculated on. A lot of others in the community had speculated on, and now, for the first time, as far as I'm aware, we have actual confirmation of that. So I'll share with you the specifics. But before going further, I do want to be clear. I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say, all right? I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, shout out and credit to attorney James K. Filing for sharing this document. Also, John Deaton's Crypto Law Organization shared this document as well. Unfortunately, I don't have any perspective from attorney John Deaton at this particular juncture in time. He hasn't shared anything that I've seen on social media, but he's also running a Senate campaign, so he's probably a little bit busy, so easily forgivable. But I do have perspective from attorney Hogan, attorney Bill Morgan, attorney James Murphy, and attorney Fred Rispoli. So here's a post from Stuart Alderati. Of course, he's Ripple's chief legal officer, their top in-house lawyer. And here's what he wrote. Our opposition to the SEC's request for $2 billion in penalties for legacy institutional sales is now public. In a case that had no allegations or findings of recklessness or fraud, and in which Ripple won on significant issues, the SEC's ask is just more evidence of its ongoing intimidation against all of crypto in the United States. We remain confident that the judge will approach this final remedies phase fairly. Yeah, and I'm very optimistic for that as well. The SEC hasn't been getting away with much of their BS, right? Let's just say that. It's pretty safe to conclude we're more likely than not Ripple's going to think that the final outcome is going to be okay. Not that I'm thrilled that they necessarily have to pay anything, because I think all of the entirety of this thing is bogus, but it is what it is. Ripple CEO Brad Garlinghouse reposted that from Stuart Alderati, and Brad wrote the following. Feels apropos that we file our response on the same day that 2 SEC lawyers resign, in quotes, for their misconduct in the debt box case. The U.S. will be picking up the pieces of the agency's disastrous policies long after Gensler is gone. And in case you hadn't heard, I just mentioned it, these are the 2 SEC asset prick attorneys that ended up, quote-unquote, resigning. And I don't want to spend much time on this. I want to focus on the main topic at hand here, but I'll just briefly mention this just so you know what did happen. Here's that line from CoinDesk. 2 SEC lawyers resign following debt box sanctions fiasco, Bloomberg. 2 lawyers from the U.S. Securities and Exchange Commission were forced to resign after a federal judge sanctioned the agency last month for committing a gross abuse of power, and that's a quote, while attempting to secure a temporary restraining order against Utah-based crypto company DebtBox, according to a Monday report from Bloomberg. And so I reported on that thoroughly at the time. It's just a repulsive act. These people are just despicable humans, so far as I'm concerned. So it is kind of funny that happens on the same day, and that's what Brad Garlinghouse was talking about, just so you know. Here is a post from attorney Jeremy Hogan. The SEC has big legal problems to address if it wants to get a win against Ripple, and I still think it squandered its opportunity to get ahead with its first brief. I will be going live tomorrow to discuss on Crypto Law US. $1.95 billion or $10 million, or what will it be? So I'm looking forward. I'm going to check that out tomorrow. I don't know if I'll be able to literally live, but I'm going to check out that video for sure. I'll be very curious to see what he has to say with attorney John Deaton on YouTube. Here's a post from attorney Bill Morgan. He shared a screen grab from the filing, and which I'll read in a second, but first I'm going to read to you what attorney Morgan said. He said, in summary, I think this argument is correct, and disgorgement should not be awarded where it would give investors a windfall. Ripple looks in good shape for Torres to apply Govil and order no disgorgement. And so they're just referencing a separate case, the Govil case. And what they're getting at here is, I mean, it's just, it is a matter of fact that Ripple's customers were not financially harmed as a result of any of these transactions. So if there were some sort of disgorgement here, then the customers, which were not financially harmed, would just have this windfall of profit because reasons. Completely absurd, obviously. So that's why Judge Torres should not allow that to happen. I don't think she will. But the screen grab that he shared reads as follows. And again, it's referencing a separate case, the Govil case. Govil's logic applies here even more strongly. Ripple committed no fraud. It made pre-complaint institutional sales to 41 buyers. After years of investigation and more years of discovery, the SEC does not and cannot point to any institutional buyer that lost money as a result of purchasing XRP from Ripple. Instead, those buyers received the benefit of their bargain. Any disgorgement for them would be conferring a windfall. So think about this. Not only can the SEC, and believe me, they point this out if they could, but not only can the SEC not point out to a single Ripple customer being financially harmed as a result of any of this, despite that being the case, they're seeking $2 billion in penalties and disgorgement. $2 billion. That is laughable. I can only imagine that when Judge Torres first saw that that's what the SEC seriously suggested, I can only imagine that she laughed hysterically. Because that is ridiculous. How can you even take that seriously? It just doesn't even make sense. Here's another post from attorney Bill Morgan. And he just shared another screen grab. And he wrote, I have argued for 3 years that ODL contracts are not investment contracts. And at last, Ripple makes cogent arguments that ODL sales are not investment contracts, as the ODL customers only hold XRP for a few seconds, not as investment, but to effect a cross-border payment. Not only can't the ODL customer expect profits from buying XRP as an investment, but it can't earn profits from the purchase. It is prevented from doing so by Ripple's contracts. So how about, that's why that's another reason this is all ridiculous. So the ODL stuff, the way Judge Torres ruled, look, I don't agree with it. I've talked about it before. I talked about it when the ruling came out July of last year. But at least for us XRP holders, we got the only piece that specifically matters to us, which is that XRP itself is not a security, which is why literally within hours of that news coming out, that decision being made from Judge Torres, multiple cryptocurrency exchanges the very same day relisted XRP, way faster than I would have guessed. I was very happy to see that. Here's a post from attorney James Murphy, goes by Meta Lawman on X. As we anticipated, Ripple argues no victims / no disgorgement, relying on the recent Second Circuit case I discussed with Scott Melker in the clip below. And then here's a quote from Ripple. After years of investigation and more years of discovery, the SEC does not and cannot point to any institutional buyer that lost money as a result of purchasing XRP from Ripple. End quote. Ripple argues for $0 disgorgement and a penalty that does not exceed $10 million. So, those are the goalposts. SEC wants $1.95 billion. Ripple says less than $10 million. The SEC will get one last brief on the damages question, which is May 6th, and then it's off to Judge Torres for decision. Yeah, so we're going to have final word on this soon, and well before this bull run is over. I mean, that's what's likely anyway. Who knows? Maybe we'll get a decision on this in May. Maybe it'll be early June. We'll see. but it's a virtual certainty that we're going to have this thing concluded before the end of this bull run. And I mention that only because some people think that it matters. I'm not convinced that it's going to matter to the typical XRP holder, the typical speculator out there, because XRP already has its legal clarity. That's the part that matters. Whether or not Ripple has to pay $0 or actually does have to pay almost $2 billion, which is absurd. No matter what it is, I just don't see how it matters to the typical XRP holder or speculator. That doesn't make sense to me. So if the market moves, which, fine, I mean, I can't imagine it's going to be something too meaningful, but I acknowledge, I guess it's possible. I just don't think it's remotely probable that even if it does move on the news, again, it's just irrational. And I just, maybe it'd be one of those short-lived things, but I'm not even as confident about that. Like, if XRP price actually starts to move, given that we're in a bull market, who knows? Maybe people are going to be that exuberant about it, but it'd just be kind of silly, because the piece that mattered happened last July, and the only reason that it didn't run higher than it did last July is because Bitcoin was in a downtrend and XRP follows the market. So without expansion in the market, it shouldn't be surprising that happened. Like, XRP's never gone on a crazy run and hit a new all-time high if there's not expansion going on for the entire crypto asset class, and there wasn't at the time. So now, if you start to see that, if things line up a certain way, okay. Excuse me. But either way, I don't think that this actually matters. Do you, like, answer for yourself, you listening. Tell me in the comment section below. Does it matter to you? Are you going to be more confident in XRP based on whatever happens in the remedies portion of this trial? Because I don't see the logic. How does it matter to you listening to this as an XRP holder? It does not make sense. Anyway, here's what attorney Fred Rispoli had to say. Here's my hot take on Ripple's opposition to Remedy's motion. The too long didn't read version is that anything greater than $10 million total would be unfair and inappropriate. Ripple is in a great position to win this one, but there are, unfortunately, ominous signs. First, as predicted, Ripple has changed its operations to account for the court ruling. It's kept all its major ODL offshore, mainly in Singapore. Torres, in my opinion, will not get into a factual fight on an incomplete record, so Ripple wins because SEC can't carry its burden. Interestingly, or sadly maybe, for US ODL, we have confirmation why Ripple decided to issue a stablecoin to allow US-based clients to use ODL but not XRP. Also, great to see Ripple shove SEC's statement about losing in its face. So let me pause right there, and I do have the actual document. I didn't see, maybe I missed it, I didn't see what he's talking about there. So here's what I did see. This is on page 7. Ripple's, and this is what Ripple's attorneys wrote. Ripple's remaining ODL business in the United States uses a non-XRP bridge currency. So they're using something else right now, today, I don't know what. They didn't say. Probably not Bitcoin. I would hazard that guess. They could be using a stablecoin. They could be using, what if they're using Tether? I don't freaking know. I have no idea. It's not XRP though, because they can't. But they don't feel like they can right now. So the part that I didn't see, because he wrote here, now we know why Ripple wants to launch a stablecoin. Well, they already have a solution. So unless I missed something, I don't see that as the reason that they're launching a stablecoin. In fact, from what I'd gathered in the way that executives had talked about launching a stablecoin, I think a lot of it had to do with the fact that Ripple's just trying to do all things crypto. They're trying to be basically like the infrastructure of the entire crypto space to the extent that they can possibly pull that off. That's why they've gotten into custody when they bought up Medico in May of last year. That's why they're getting into the stablecoin business. There's a lot of profit to be made, in doing so. So I think that that's probably the primary driver. Now, if they end up using their own stablecoin as a bridge currency in corridors where that are touching the United States, yeah, I could see them doing that. I could. I've talked about this before. Like, that wouldn't be surprising. All I'm saying, and this is, I'm just kind of, it might sound like I'm nitpicking, but all I'm really just noting, I didn't see, and again, I could have missed it. Maybe Fred Rispoli saw something and I just missed it. But I'm not seeing where Ripple has indicated that that's why they're launching a stablecoin. And again, they already have a solution. They're using something else that isn't the stablecoin because it doesn't exist. Not theirs anyway. And I just don't know what it is. But this is not surprising. Again, I said this many times before. Either way, the utility for XRP as a bridge currency, it still exists and it's still there. Anyway, Attorney Rispoli continues, though. Let me take a sip of water here. Sorry, folks. 1 second here. You're welcome for me coughing away from the microphone. I swear, it seems like most YouTubers, when they do have to cough, it's almost like they're intentionally leaning into the damn microphone, getting closer. Knock it off. And see, that's how incredible I am for you listening. I turn my head to the side. Anyway, so Attorney Rispoli continues. We're right here, I think, right? Also, Ripple. Yeah, here we go. So, Exhibit A is a lengthy declaration from Ripple President Monica Long that reveals some interesting business practices like stopping institutional sales in 2019. Ripple is aiming for money transmitter licenses in 45 states and changing ODL contracts. Lots more to dive into here, and I still need to. Bad news, the parties are teeing up or posturing on round 2. Yeah, check this out, folks. This would not be good. I mean, XRP is legal clarity, so it's like, okay, whatever. But this wouldn't be good for Ripple. It wouldn't be desirable. But check this out. Ripple tells court if SEC wants to sue on the new contracts, it needs to bring a new enforcement action. SEC getting hammered with a low penalty will help in dissuading a repeat enforcement action. I was right. Ripple did throw in the debt box case. Not incredibly relevant, but if the SEC wanted to throw X posts in the judge's face, then Ripple be one-upping it with throwing job-ending sanctions out there. And you gotta love that. That was a good call by Attorney Rispoli there. And he says, the number of characters redacted on page 23 are 11 or 12, meaning less than $9 million at most. This is where Ripple got its $10 million number from. And SEC has the gall to ask for $2 billion when it only sanctions its boys a couple million. Not going to persuade Judge Torres here, SEC. And then he notes at the end, to kind of wrap this up, that his prediction is that Ripple pays $25 million or less. So that would be the max, $25 million. Yeah, and so since I'm not an attorney, I'm not even going to bother making the predictions. I hope that's right. I don't think it's going to be anywhere near what the SEC is asking for. Those asshat pricks are out of their goddamn minds. What the hell? $2 billion? No fraud, no recklessness. SEC can't even point to any actual losses from Ripple customers. There aren't any. Nobody was financially harmed. And $2 billion? Get the hell out of here with that nonsense. That's why I said earlier, if I'm Judge Torres, I'm laughing the first time I see that that's what they're suggesting. It's just a disgrace. What an awful agency. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.